Welcome to another episode of the Carry Trainer Higher Line podcast. Hey guys, welcome to another episode of the Higher Line podcast. Got to tell you again that today's episode is brought to you by Gunfighter Gun Oil, the world's best lubricant, 100% synthetic. We've got author, attorney, legendary masterclass shooter, Andrew Branca on today. It is the 2nd of September. Kind of crazy that it's already September. And if you guys don't know who Andrew is, he is a writer, educator, and attorney in the field of self-defense. Andrew, how does that differ from criminal law?
Well, most criminal defense attorneys have what I would call a generalized criminal defense practice. So they'll do shoplifting cases, DWI cases, all kinds of stuff. I only do use of force cases, which means self-defense, defense of yourself, defense of others, or defense of property. Those are the only cases I do. And as far as I know, I'm the only attorney in the country who has that specialization. Really?
Yep. That's interesting. Why would that be?
Well, you can't make any money doing it as a normal law practice. So I have a very unusual law practice. I don't take clients directly. All the cases I work on, my clients are other attorneys who are lead counsel on their cases.
Okay.
So as a result, the scope of cases I work on is nationwide. Most small town attorneys, all their work comes from whatever town they live in. So they have to take a wide variety of cases in order to pay the bills. Because of my specialization and the fact that I'm really a legal consultancy, an attorney who works for other attorneys, I'm not limited to cases from my local jurisdiction, my local geography. I can work on cases all over the country. So that enables me to make a living doing this in a way that's different than most traditional criminal defense practices.
So for us non-attorneys, because you're working under the purview of the attorney that hired you, you don't need to be barred in every state.
Correct. Okay. Absolutely.
Very cool. So I know there's many companies that have popped up, and I want to talk about a few things, but just to kind of set the tone for people listening, there's tons of companies that have popped up that sell insurance type products. You and I both do work, full disclosure, with one of those companies. And that's not what the purpose of the podcast is, but it seems to be like a sticking point for some of the consumers that purchase those products, that they want to be able to go out and pick their own attorney. What's your comments on that?
Well, I certainly think it's important to have the privilege to be able to pick your own attorney. Like any other kind of profession or trade, there's a wide variety in quality among attorneys. Some are world-class, some are less than world-class, some are pretty bad. You don't want a pretty bad attorney when your life is effectively on the line. And life as we know it is on the line. For most of us who are normal law-abiding people who've never been in trouble with the law before, we're facing a felony charge. Most of the cases I work on are aggravated assault with a weapon charges. In most states, good for 10 to 20 years in prison. And most of the cases I work on are normal people just like us, never been in trouble with the law before, and they're looking at a decade or two in prison. If those are the stakes, you have to have absolute confidence in your attorney. And I wouldn't want an attorney somebody else picked for me. I would want an attorney that I knew I was comfortable with.
So I guess where I was going with that is, it seems like a lot of folks, when I've had this conversation with them, their discussion is, well, I'm going to go find my local hotshot criminal guy. And as you just pointed out at the beginning of the discussion, a lot of those guys or gals are not specialists in the defense of folks that are using righteous force.
Right. So that's actually a separate issue. So it sounds like what you're referring to now is people want to go out and identify a lawyer ahead of time. So they have someone's business card in their wallet. I actually don't recommend that. I don't think that's very useful. For one thing, most people are not capable really of evaluating the quality of an attorney they've never met with, never worked with, never spoken with before. If you're actually involved in a use of force event, well, then you're actually talking with an attorney about an actual fact case, something that happened to you. And that gives you kind of the substance from which you can determine whether or not it sounds like that attorney knows what he's talking about. If you just pick an attorney out of the phone book and say, I'm going to carry his business card, you have no idea if that attorney's any good. And by the way, when are you going to need that attorney? Tomorrow? 5 years from now? 10 years from now? 15 years from now? And one of the reasons we at Law of Self-Defense, we don't recommend attorneys ahead of time. And I get this request all the time. Hey, I'm in California or wherever. Can you recommend an attorney just in case I ever need one? We tend not to do that, because even if I could recommend the best attorney for you today, that doesn't mean they're the best attorney for you when you need them 5 years from now or 10 years from now.
Sure. People retire, die.
Or they change their practice, or lots of things can happen. Or a better attorney can come up. Yeah, exactly right. So, of course, Law of Self-Defense has, as part of its services, a membership program. If any of our members are involved in a use of force event, then we're happy to recommend the local attorney to them that we think is good. But we tend not to do it prospectively, because it's just not that helpful. The truth is, if you're involved in a use of force event, that first attorney you get, all he's really going to do is go to your arraignment. He's going to arrange for bail, assuming the court's going to grant bail. But that's not necessarily the lawyer who's going to argue your case at trial. There's no reason for them to be. You want to get out of jail, you want to get bailed out as quickly as possible, but really any criminal defense attorney can do that. That's not a complicated task. And then after you're bailed out, then you can, at your leisure, interview as many attorneys as you need to find the one that you're most confident in. Frankly, one of the great things I like about CCW Safe, which is, of course, this legal service membership that both of us have some relationship with, full disclosure, they are a sponsor of some of our Law of Self-Defense content, is they have this, essentially, I forget the term they use for it, but it's kind of a quick reaction force, a quick reaction team that comes on the spot immediately in the aftermath of a use of force event. And one of those people is attorney Don West, who many people may know was one of the attorneys for the George Zimmerman trial. A fantastic criminal defense attorney. I think the world of Don. And if you have Don as kind of your initial interface with the rest of the legal profession, I am utterly confident you're going to end up with a highly capable attorney representing you. And you don't need to find someone ahead of time and carry the business card around in your wallet for 10 years.
Do you think folks spend too much time thinking about this kind of stuff? And I don't want to diminish like your work or CCW Safes or even my own, but sometimes I find, for example, you're a masterclass IDPA shooter. So that means you've invested a ton of time and resources in developing that skill set. I find that, like with our students or just questions we get in general, folks spend so much time concerned about getting jammed up legally. Do you see that?
Well, what I really observe is that people spend too much time thinking about that inefficiently. And actually, I would draw a parallel to that to my own competitive shooting career. I became a master class shooter probably in the most inefficient way possible. I just went to the range and I fired thousands and thousands and thousands of rounds. Since then, I've learned much more efficient ways of gaining skill and using a firearm, much more effective means of dry fire. If I knew then what I know now, I would have saved myself thousands and thousands of dollars in ammunition costs and become a masterclass shooter a year, 2 years, 3 years sooner than I effectively did. But I was ignorant. I didn't know what the most efficient process was. I think there's a parallel between that and how most people think about these legal issues. It's not that there's anything wrong with them thinking it through or investing time and effort in doing that, but they're doing it incredibly inefficiently because most of what they know about self-defense law is bad information. They've been mistaught, misinstructed. So all this effort they're investing in trying to figure out what to do from a legal perspective in use of force events is based on a corrupt foundation. It's simply not productive effort. Now, the truth is self-defense law is not very complicated. For any claim of self-defense, there's only up to 5 components, 5 pieces to the puzzle, not 500, not 50. It's actually a very straightforward area of the law. So it's not hard to learn it correctly. But unfortunately, there's so few sources that people can go to for good information, and there's so many bad sources of information. Almost all self-defense law information generally available is bad information, not out of malice, not because anyone's trying to lie to anybody or firearms instructors are just making stuff up, but they've been poorly taught themselves.
It's very interesting. It is interesting how much bad information is proliferated.
It's unbelievable. It's everywhere. It's thick on the ground. And unfortunately, people sometimes assume that because someone has a particular job title, that they must know the actual law of self-defense based on actual law, statutes, jury instructions, court decisions. And I'm talking about job titles like firearms instructor or police officer or lawyer, for that matter. Mm-hmm. I can tell you in 3 years of law school, we spent maybe 3 or 4 minutes on self-defense law. So we're not taught this stuff in law school in any depth at all. Police get a lot more training in self-defense law than lawyers do, but most of what police are taught is not actually intended to protect that officer from criminal liability himself. It's intended to protect his department from civil liability when they get sued for his use of force. So it's not in his interest, it's in his department's interest.
Interesting.
And unfortunately, most firearms instructors, a lot of what they're taught simply is not based on actual law. It's based on kind of this collective institutional knowledge, this internet type knowledge that everyone, quote unquote, knows is true. But when you look at the actual law, the statutes, jury instructions, court decisions, it's not actually based on law. And of all your knowledge, if your decisions in self-defense are based on what you read on the internet or what some firearms instructor taught you, and it's not consistent with what the law actually is, guess what, folks? In a courtroom, nobody cares what you read on the internet. Nobody cares what your firearms instructor taught you if any of that is inconsistent with what the law actually requires.
That's kind of the beauty of law. I have this conversation with people sometimes, and they add so much of their own emotion or interpretation based on like geographic cultures and things of that nature. And it's like, well, that doesn't equate to what the law says, because that's like carved in stone up here unless we go change it. But I think unless somebody's been on that side of the equation where they're maybe not even with something as serious as a use of force case, but just stood before a judge and understood how that process works, it's easy to just adhere to those dogmas.
So one way that people get in trouble is there is a lot of discretion built into use of force law. This is discretion largely on the part of prosecutors. So prosecutors could have a case that's 100% locked for a conviction, but decide not to prosecute the case. That's totally up to them to make that decision. And sometimes people will read about a use of force event in the news or on the internet, some kind of anecdote, and they'll hear, well, this person did such and such, and they weren't arrested, they weren't prosecuted, they weren't convicted, and they'll assume from that means that what that person did was lawful, was consistent with the law. Well, it may have been, but it may not have been. It may have been an act of discretion by the prosecution simply deciding not to take that case. That same prosecutor with the same facts the next week could decide to prosecute that second case. And we always caution, it's so dangerous to learn self-defense law from these kinds of news anecdotes in the absence of knowing what the law actually is. Because if you don't know what the law actually is, you don't know if that outcome was a function of the law being applied or a function of the prosecutor using his discretion. You always have to assume the worst case scenario, that you're not going to be dealing with a prosecutor who wants to give you a break, right? When we prepare for physical self-defense, we don't prepare for the rapist that's going to stop if we ask him to stop, right? We prepare for the aggressor that will not stop unless we use defensive force. I always caution people, you have to be prepared for the prosecutor who will not give you a break, who will not use your discretion, his discretion on your behalf, for the prosecutor who wants to put you in prison for much of the rest of your life. Because if you're prepared for that guy, well, then if you get a lucky break from a prosecutor using his discretion, that's all good. But if you only prepare for the prosecutor willing to use his discretion on your behalf, and then you run into the prosecutor who wants to convict you, then you're just out of luck.
That's a good analogy from like a combative standpoint to the legal preparation. What are the five elements that you discussed?
No state secret. They are innocence, imminence, proportionality, avoidance, and reasonableness. In fact, we have this handy dandy infographic we just give away for free. If people are interested in it, it's just a free PDF download. They can get that at lawselfdefense.com/elements, plural, for the 5 elements of self-defense. It's our 5 elements of self-defense law infographic. List the 5 elements, provides a brief description of those. It's not all you need to know, obviously, in a single page, but it's the absolutely essential foundation. If you don't understand these 5 elements of self-defense law, you can't possibly understand how the laws actually apply to use of force cases. And by the way, these 5 elements apply in all 50 states. Self-defense law is pretty common across the 50 states. By self-defense law, I mean defense of persons, self-defense and defense of others. Defense of property varies a lot from state to state, but defense of persons is pretty consistent, about 80% consistent across the states. Now, every state has its own statutes, jury instructions, cases, but the underlying legal principles are fairly consistent, and that's because of how old self-defense law is. This is not a new area of the law. This is law dating back thousands of years to ancient Greek and Roman times and probably prehistory times. Man has always had a need to be able to defend himself from aggression. And because of how old that law is, it has very common foundations. So those 5 elements are applicable in every state. The only exception would be sometimes one or more of the elements might be legally waived for some reason. So, for example, one of the elements I listed there was the element of avoidance. That has to do with whether or not there's a legal duty to retreat. The majority of states actually waive that element of a duty to retreat in many circumstances. These are the stand your ground states. About 36 of the 50 states are effectively stand your ground states. So in those states, under normal circumstances, you're only dealing with 4 elements. So it doesn't have to be all 5. One or more of those elements can be legally waived, but 5 is the maximum number that you need to worry about.
Stand your ground. Let's talk on that for just a sec. And this wasn't my intention to go deep into some of these things, but you're laying out some good info. The stand your ground, castle doctrine. Let's talk about both of those things briefly. 2 completely often misunderstood and mistaught principles. You pick either one.
So they're closely related, but they're not quite the same thing. So every state has some version of castle doctrine, and castle doctrine needs to be properly understood. Too many people use that phrase to mean something broader than it actually means. Like they'll use the phrase castle doctrine to mean, hey, anything involving my home, I'm free to use deadly defensive force. That's not what castle doctrine means. Castle doctrine actually has a very limited meaning. And the limited meaning of castle doctrine, properly understood, is this. If you would otherwise have had a legal duty to retreat before you could use force to defend yourself, you're relieved of that legal duty to retreat if you're defending yourself against an aggressor in your home. So it doesn't give you special privileges to use deadly force. It doesn't give you special privileges to use force sooner. It only relieves you.
As long as you drag them across the threshold, you'll be fine when the cops get there.
Yeah, that's another issue we can talk about as well. Completely very concerning because, of course, how often that cliche is repeated. Now, in most states, castle doctrine doesn't really matter because most states are stand your ground states. And in a stand your ground state, you're relieved of an otherwise existing duty to retreat wherever you lawfully are, whether you're in your home or not. So if you wouldn't have a legal duty to retreat in a public street, you certainly don't have a legal duty to retreat in your home either. So in the majority of states where they have stand your ground, castle doctrine is kind of duplicative of the stand your ground provision. But there are about 14 states that do impose a legal duty to retreat if safely possible, if you're in public, before you can use force in self-defense. In those states, castle doctrine matters because normally you'd be required to retreat, and if you fail to do that, you lose self-defense as a legal defense, but you're relieved of that duty if you're in your home. So there's different rules for being in the street and being inside your home in those roughly 14 states that are duty to retreat states.
And of course, there's so many nuances to some of those things. For example, I've got a cast on my leg and can barely walk, or I've got my 4 children with me. I clearly can't run away from the bad man and leave my kids in the parking lot.
Right. So a legal duty to retreat, even in the states that impose it, is only ever required if retreat is possible with complete safety. You're not required to increase your jeopardy to try to retreat. And of course, any legal duty can only be required if it's practically possible. If it's impossible to retreat, well, then effectively there's no legal duty to retreat. The law can't require you to do something that's impossible. And what's a safe avenue of retreat for one person may not be a safe avenue of retreat for another person. If you're young and healthy and fit, you may be able to run away from a fight. If you have that cast on your leg, or you're older, or you have a hip replacement, or you're with somebody like that. So you're with an elderly parent or you're with a small child. You're not required to leave that person behind. So I mentioned there's only these 5 elements of self-defense. It's a pretty straightforward legal framework. And it is pretty straightforward. It's not rocket science. But what does get complicated is the real world. facts are complicated. So applying those 5 elements to complicated fact patterns can be challenging if you haven't thought them through before. And one of those complications can be things like, all right, well, element of avoidance, whether or not there's a legal duty to retreat. Some states have it, some states don't. Sounds simple enough. But then we get into these factual details like, well, I have a cast, or I use a walker, or I have a heart condition, or I'm with a child, or I'm with a parent. It's not the law per se that gets complicated, but it's applying the law to those complicated real world fact patterns.
The totality of all of the circumstances at play. Mm-hmm. I think a great case is the one you just wrote on about what happened near me in Kenosha, Wisconsin last week with the young lad who actually just lives 15, 20 miles from us. People look at that case and they just pick one component of it and say, my viewpoint's accurate because of this, but they took out a whole other swath of information. Comment on that a little bit.
Well, of course, there's, like many of these politically charged cases, there's people take sides, right? They go on teams and then they largely ignore what the actual facts are. This happens in a lot of these cases, the George Floyd case, the Michael Brown case, the George Zimmerman case. One of the things we have to do as an attorney, of course, is we need to be prepared to go into a courtroom, and every argument we want to make has to be supported by actual evidence. People talking on the internet don't have that constraint. They just make stuff up. They just believe stuff that's untrue. For example, one of the many things you'll hear about Kyle Rittenhouse is, well, he crossed the state border with that rifle with the intent to murder someone. Well, there's no evidence for any of that. There's no evidence he carried the rifle across state border. There's no evidence he had any murderous intent. That's just made up. That's a complete fabrication. Well, you can make that argument on the internet, and maybe a lot of people will believe it. They won't be able to make that argument in court unless they can show evidence of that. Now, if it turns out, for example, that he did carry the rifle across, well, they'll have to show evidence of that. If it turns out he has, I don't know, internet, social media posts where he says, I'm going to go to Kenosha and kill somebody, well, that would be evidence of an intent to go there to murder. But no such actual evidence, to my knowledge, exists. So we have to be very careful when we hear these narratives on either side, pro or for a particular person, that we always ask, well, where's the evidence in support of that argument? Because if there's no evidence, for legal purposes, it doesn't exist.
That's a really great, simple sounding board. Where's the evidence? It seems like in this modern world, I assume humans always did this, communicated like we do, where we are quick to judge. But this flow of social media information being so aggressive, pounding you, people just see it and throw an opinion out immediately.
Now, the reason we have courts and we have all these complicated rules of evidence, rules of criminal procedure, is because people do not normally think this way. Normally, people rely on things like hearsay and gossip and emotion to make their decisions. And one of the purposes of the American legal system is to strip that out of the process so that we're dealing with evidence, actual facts, demonstrable facts, and the law. And we strip the emotion out of the equation. Jurors are not supposed to be coming to verdicts based on emotional reasons. Every verdict they arrive at is supposed to be based on the application of their powers of reason, rational reason, to the evidence presented to them in the context of the law as the judge instructs them on the law. And we have all these rules about how hearsay evidence is not permitted and what kind of expert witnesses are permitted because we're trying to we want the court to act as kind of a gatekeeper on the kinds of information and legal arguments, the kinds of evidence and legal arguments that the jury is using to arrive at that verdict.
Give us an example of hearsay evidence. Would that be like Kyle drove across the border with a rifle to kill somebody? Is that hearsay evidence?
Hearsay evidence would be an example. Say we had a witness who says, I was with Kyle an hour before these shootings happened, and he told me he was there to kill somebody. Well, that's hearsay because it's a statement being introduced in court, an out-of-court statement being introduced as evidence in support of the truth of that statement. But a better example would be if they didn't hear Kyle say that, but he said, I heard someone else said that Kyle said this.
I see.
Well, what you want is you want the witness who actually heard the statement, not a second person or a third person removed. And the reason we don't like hearsay evidence, somebody repeating what someone else said, in court is because you can't cross-examine the person who made the original statement. You can't cross-examine them for bias or lying or ulterior motive. So the requirement under the law is to bring in that original witness so they can talk about what they have personal knowledge of and be subject to cross-examination by the other side.
Makes sense. How do you even find a jury in this modern world with a case like this, where they haven't been so completely tainted by what's going on?
It's always a concern, and frankly, it's one of the reasons you really need a top-shelf legal defense that's extremely well-resourced. So I'll give you an example. In the George Zimmerman case, they had a week or so of jury selection in that case. And one of the jurors who came up from the jury pool was being subject to what they call voir dire. That's where the lawyers question the prospective juror to see if they have any bias or any reason they shouldn't be on the jury. And this one gentleman said, nope, no bias, completely open-minded, haven't come to any prior conclusions about the events. And then Zimmerman's defense team, some of their staff, looked at this guy's social media accounts, and he essentially had social media memes of Zimmerman hanging from a noose. Zimmerman as a racist murderer.
I remember that.
So the defense team caught that, and obviously they kept that guy off the jury. But if that guy had been on the jury, and it was a jury of 6, under Florida law, you can do that even for felonies. If that guy had been on the jury, had been one of those 6 jurors, Zimmerman would never have been acquitted. That person was not open-minded. They were going to vote for guilt no matter what. And even if all 5 of the other jurors believed it was lawful self-defense, and as we know, every single juror, in fact, believed it was lawful self-defense, it would have been a hung jury. And the prosecution would have just tried Zimmerman again and again and again and again until they finally got a conviction. Now, Zimmerman's legal team was able to catch that guy because they were so well resourced. If you watched the trial, all you ever really saw for the most part was Don West and Mark O'Mara as George Zimmerman's lawyers. But there was a whole team behind those 2 guys. There was maybe another dozen people. When you have those kinds of resources, you can do that kind of research on the jurors. If you're one attorney working by yourself, or even 2 attorneys working by yourself, man, you have to sleep sometime. You just don't have 24 hours a day to work in the case, and that kind of catching that kind of detail gets lost. Unfortunately, the corollary of that is to have a really well-resourced legal team requires a lot of money. All those people need to get paid. So you're not just paying the attorney, who's expensive enough, by the way, or 2 attorneys, so double the expense. You're paying for 12 people or 15 people to work on your case. And I know from Don that the billables in the Zimmerman case approached $1.7 million in legal defense costs. Most people don't have that kind of money stuffed in a mattress just in case they're attacked by some physical aggressor, which is one of the reasons I like organizations like CCW Safe that can be basically a financial backer to make sure you have the resources you need to fight the legal battle the way you want to fight it, which is as if your life depends on it, because for all practical purposes, your life depends on it.
The Zimmerman case or the Rittenhouse case, people ask me about it, and I hear your opinion, but I listen to those kinds of things, and I say, if we go back to the beginning, how could that person have just not been involved in that at all? And guys don't like that kind of discussion because, well, what happens when I'm forced into it? But these people weren't. They weren't forced into it. There's always like a moment, like when a young man decides to go to a town away from home and arm himself and walk in the street, or when a guy decides to be the town constable and chase a potential bad guy down in the dark. And I'm not weighing judgment against either of them, but there's always a moment when somebody makes a decision that puts them on a collision course with trouble.
Right. So my position always is I don't tell other people what to do. So I would not tell Kyle not to go to that town like I was his father, forbidding him from doing it. What I try to inform people on are the risks they're incurring when they engage in that kind of behavior. If you know the risks and it's an informed decision, well, then you're assuming the risk. Kyle assumed the risk that he would be involved in a deadly force confrontation when he did that. Now, that doesn't make his conduct unlawful, doesn't mean he did anything criminal, but it does mean he put himself in a high-risk situation.
Mhm.
And as events turned out, he incurred the costs of those high-risk situations. Even if he's acquitted of all these criminal charges, as in my opinion, based on the evidence we currently have, he ought to be acquitted, perhaps with the exclusion of the gun offense, because I don't do gun law, so I'll leave that off the table. But for all the use of force offenses, I don't see any of them that he ought to be convicted on in this case, based on the evidence we know. But it's going to be a very costly win, even if he does win. It's likely going to cost him hundreds of thousands of dollars, and maybe years before he ever has anything like a normal life again. I mean, to this day, George Zimmerman, for example, has made enormous strides in recent years in getting back to something resembling a normal life. But that case happened a long time ago. That was
10 years?
2012, 13, 14.
Okay.
So it's a long, hard road back. And of course, many people will always think of Zimmerman as some kind of racist murderer, which there's absolutely no basis, in fact, for. But when most people only know what they're told, and what they're told they see in the media or on the internet, and if they see 10,000 times that someone's a racist murderer, well, they just come to believe that. And once they've become emotionally committed to that view of the world, it's almost impossible to shake them free of it. I mean, I give a lot of talks to law enforcement. I lecture at the FBI Academy, and I've given talks about this at the FBI Academy, and I'll ask them, I said, well, how many people, and this is an audience of 200-300 FBI agents, senior law enforcement from all over the country. I'll say, how many people believe X happened in this case? And all the hands go up. And then I'll show them the evidence that X couldn't possibly have happened in that case. And about half the people will go, oh my gosh, yeah, I didn't know that. That's good to know. The other half, they simply cannot accept the evidence you put in front of them. They are so emotionally committed. They just choice. Cannot break free. And no matter how much evidence you show them, it will never change their minds.
It's like a kid trying to eat lima beans. Mm-hmm. That's scary when we start to look at how hundreds of thousands of people formulate opinions on this kind of stuff, and in other social issues. This is what's going on in America right now. People make choices and then take action on their choices without facts, on completely biased opinions, and then just like your hearsay, then those biased opinions get repeated to others, and we end up with things like drag the body into the door, sweep a little dirt onto the blood stains. And
absolutely. Well, the bottom line is that propaganda works. If propaganda didn't work, people wouldn't do it. And our modern media today in America is largely a propaganda organization. They have talking points completely disconnected from whatever reality or truth there may be, and they just repeat them endlessly, and the effect is a kind of brainwashing of the public who, let's face it, it's not their job to dig into the details and facts of all these cases. They have their normal jobs. They're plumbers or teachers or whatever they might be. They're spending maybe 2% of their time thinking about these cases, and 98% of what they're hearing is the narrative being propagated by the media. So that's what they come to believe is true. Not because they're bad people or they're stupid or anything like that. That's just how people normally operate. They're just being normal people. But the effect is the equivalent of a kind of brainwashing operation where they're led to believe something to be true that simply has no basis in actual fact or evidence. And of course, that forms their worldview. And it's a profoundly defective worldview, but it is what it is. That's what they actually believe.
It's very challenging. I think we both commented on it earlier. I don't think humans are any different than we've ever been, but it's very challenging to disseminate information. In the last year, I've been called a Nazi, a racist, which I'm neither, a bigot, merely for posing a question such as, perhaps there's other data here we haven't seen. Maybe we should look for that. Well, F you, you're a racist. Well, wait a minute. I didn't say anything racist at all. All I'm proposing is that maybe we should look a little bit deeper.
Yeah, well, welcome to the club is all I can say. I mean, I hear those things just about every week. But it's one of the reasons I do law for a living, because at the end of the day, the arguments I need to make are going to happen in a courtroom, or at least associated with a courtroom, where we can, again, strip out that emotion, strip out that propaganda, and compel the other side to support their arguments with actual evidence. And if they can't do that, well, then their arguments fail in court. Ideally, of course, that's what we hope for. So you can fight the battle in the courtroom in a way that you really can't in a public forum. In a public forum, and I do, of course, a lot of public writing and a lot of public speaking, a lot of videos, a lot of podcasts, and I present all this information to people. And fortunately, we have enough people who are interested in our take on these things that we have a functioning law practice here. But that's a tiny fraction of the 350 million people who live in the country. And most of the people I'm able to communicate with are people who are actively interested in hearing what we have to say. I mean, they pay to be members of Law Self-Defense. And thankfully, they're very appreciative of what we do, and we thank them for their support. The more people I can reach, the better, obviously. So we're always striving to do that. But I'm at the end of the day, I'm a small town lawyer, and the rest of the world out there is the national media that's hitting people 24 hours a day in every airport in the country. So in some senses, it's an uphill fight. The good news is that it's the right fight. It's the good fight. And so it's very rewarding to be engaged in it.
What you just talked about, the amount of people, the uphill battle, my involvement in politics, this discussion, I hope you guys listening, it illustrates why it's so important that you are involved in elections for your local sheriff, your local prosecutor, the judges in your community. A lot of folks go out and they just will vote for president, which is also important because presidents are involved with appointing Supreme Court justices and federal judges. And I think too often we overlook that because the plumbers, the carpenters, the average man it doesn't go into that world unless it's for family law or something like that. And I don't care who's the judge of such and such appellate court or appeals court or state Supreme Court until you start to look at cases like some of the stuff we're talking about, or somebody being maliciously prosecuted. So it is super important. I'm not talking to you so much as the listeners, that you are engaged in your local elections on that stuff.
Yeah, we see a lot of interesting things happening in prosecutors' races around the country these days. So most prosecutors' races would involve a couple of people who've spent a decade or two in the local legal profession, in their bars. They each decide, hey, I'd like to be prosecutor. They spend a few $1,000s of their own money. They run for office, and one of them wins. What we're seeing now is high-dollar political operations coming to these races that normally involve $5,000, $10,000 in campaign funding, dropping $100,000, $200,000, $500,000 in a prosecutor's race, and effectively buying that prosecutor's seat. And then that prosecutor is owned by the people who gave them that money. And that's where we see these charging decisions. I mentioned earlier, prosecutors can often use their discretion favorably for someone who's involved in a use of force case. Well, they can also use that discretion unfavorably. And we see that in cases like the McCloskey case in St. Louis. We see that, in my opinion, in the Rittenhouse case now in Kenosha, lots of other cases. And ultimately, of course, the case ends up in court. And in court, if you have a good legal defense and hopefully favorable evidence, you can still ultimately win the legal fight. But what that prosecution has the discretion to do is decide, well, either I'll let you win at zero cost, or I'll let you win after you've spent $500,000 in legal expenses, have sold your home, sold your business, destroyed your reputation. That's within their discretion, and there's no way to hold them accountable after they're in office making those decisions. So it's really important who your prosecutors are, because if bad prosecutors, politically motivated prosecutors, are in your jurisdiction, they make those calls against you, and they've destroyed your life effectively. They've used the process as a punishment, even if you ultimately end up, quote unquote, winning in acquittal at trial.
Yeah.
You're nevertheless, your life is never the same, is effectively destroyed.
And I think folks listening, even if you've got a great attorney and the money and insurance, the damage to reputation and family is huge on top of it. Yeah, and I can't say it enough. Getting involved in politics, as much as it sucks, not involved in the political gamesmanship, but in finding out who the candidates are and ask them questions. Hey, how do you feel about the Bill of Rights? How do you feel about the person's ability to protect themselves in their home from violence? And pose questions and ask them how they would treat it. Not silly questions that don't make sense, or questions that are directed to backdoor them, but legitimate questions, and you'll find out real quick. I interviewed a guy a few years ago that was running for sheriff, and I ultimately helped another candidate win the sheriff's race. But this gentleman was an attorney. He was also a deputy sheriff years ago before he went to law school. And I was in his office, and I said, hey, man, like, at the time I was running a non-for-profit that lobbied for gun rights here in Illinois. I said, what's your take on Second Amendment? And he put his feet up on his desk and he's chatting and, law books everywhere. And I'm just some idiot. And basically his take was guns only should be had by law enforcement. And he doesn't believe the current interpretation of what the founders had interpreted. And I wrote that down, and he ended up trying to burn me in the newspapers. So when the newspapers interviewed me, because I was helping run the campaign, I was like, hey, I made my decision based on this. And he had thousands of people work against him after that. But point being, that guy had a good shot at being the sheriff of a large metropolitan county around Chicago here, and that would have been a bad thing. Self-defense cases and things of that nature, and people don't pay attention to that. And then we start to have things like this Rittenhouse stuff go down, and folks just blame the liberals and they blame the media, but it's them that are to blame because they voted these asshats into office, or through lack of exercising their vote, they got them in.
Right. Passively. I mean, very few people vote for prosecutors' positions, unfortunately. So it doesn't take a lot of effort to win the seat if you can dump a lot of money into the race, because there's only a few thousand votes that are happening anyway. So they're pretty easy seats to steal effectively, or I should say buy, if you have the money to drop into the race. And it doesn't take a lot of money. I mean, that's why this is happening in the last 5-10 years is political operatives realized, hey, this is a good return on investment. For $100,000, I can own a prosecutor. And then have enormous political influence in that jurisdiction. I cannot bring charges. We see this in Portland, right? All these rioters who are being arrested by the police are put up in front of the DA, and they're out the same day. The DA's just made a political decision. I'm not going to bring charges against any of these people. So they will not prosecute their team for demonstrable acts of criminal violence, but they will prosecute anyone who's not on their team, who they perceive as politically antagonistic. I would suggest that's not rule of law. That's raw political power. It is.
It is. Folks don't like looking at that truth because it's rather shocking when you think about it. But conversely, you and I and a couple of our buddies could go into a community and completely revamp a county building with effort, putting people into office. It's work, and that's the thing people shy away from, the work that it takes to actually do it. It's sometimes multi-year investments to get that done.
Yeah, I mean, people either need to get invested in these political processes or suffer the consequences of not being invested in the political processes.
I think that's what we're paying for right now across our country. For races in general, turnouts are single digits in some areas. So you're getting single digits of the population percentage-wise controlling the outcome. So it's kind of a no-brainer how that works.
Yeah, I mean, it's no different than if a mafia boss bought a prosecutor, right? So now the mafia, his henchmen never get prosecuted for their crimes, no matter what they are. But if there's anybody the mafia boss doesn't like who gets in that prosecutor's crosshairs, that person's, even if they end up being acquitted, their life is destroyed financially, reputationally, in every way that really matters, short of actually being sent to prison. And of course, the risk of actually being convicted is never zero. The risk is always greater than zero. Just like in a physical fight, I don't care how good you are with a gun or a knife or your hands, you get into a physical confrontation, there's no magic pixie dust that says you're going to win that fight. It could not be your day. The other guy could turn out to be skilled too. So we practice and we train and we prepare so we can reduce that risk of losing the physical fight as close to zero as possible. But it's never zero. And the risk of losing a legal fight's never zero for the same reasons. And, we do a lot of training and education here at Law of Self-Defense because we want to help people reduce the risk of losing that legal fight as close to zero as possible. But it's always greater than zero, folks. So we always tell every client, every case I work on, if we have to put you in front of a jury, there's probably a 10% chance you get convicted, no matter how innocent you are.
Mm-hmm.
That's just part of the noise in the system.
Yeah, they might not like the color of your hair.
Too many of the pieces are unpredictable. Jurors are unpredictable. We all have heard this phrase, jury selection, and it suggests that, your attorney selects your jury. Folks, that's not what happens. If I could select your jury, I would never lose a case ever. I have a modest ability to deselect individual jurors from the jury pool, but I'm stuck with the overall jury pool. And when I deselect a juror and say, I don't want him on the jury, I don't know if the next person in line is going to be even worse than that.
the next ball that pops up in the bingo machine. Right. Yeah.
So there's a certain amount of randomness, of noise in the criminal justice system that keeps the legal risk from ever approaching something close to zero. So these prosecutors bring these charges. The charges could be insane. The charges could lack any evidentiary basis. The charges could be nonsense. There's still a risk you could get convicted of those charges. So I mentioned earlier, at Law of Self-Defense, we don't tell people what to do. I wouldn't tell Rittenhouse not to go to Kenosha with that rifle, but I would tell him, if you go to Kenosha with that rifle, you're putting yourself in a high-risk position. You're putting yourself potentially in the crosshairs of a prosecutor who does not have your best interests in mind. They have their own political interests in mind. And if burning you at the stake advances their political interests, they have the discretion to do that to you. Do you want to put yourself in that position? Yeah. Now, the answer is yes. All right, you've made an informed decision. But unfortunately, I think a lot of people put themselves in those high-risk circumstances without making an informed decision, without really understanding the risks that they're exposing themselves to. And unfortunately, they often find themselves really jammed up.
Yeah. You wrote a book, which is also the same name of your consultancy, correct?
I did. Let's see. Here it is, Law of Self-Defense, currently in its 3rd edition. We have a couple books. We have a lot of stuff. I really just encourage people to, I have too much stuff to talk about. We could spend the whole show just talking about our different products and services. But if they go to our website, lawofselfdefense.com, they can learn about all of that. The thing, most of our content is members only these days. The good news is people can try out a membership for 99 cents for 2 weeks. So it's very inexpensive. If they decide they don't like it, I'll give them back twice their money back, 200% money back guarantee. Very few people take advantage of that guarantee. Most people, once they become members, they stay members. But people can try that out at lawofselfdefense.com/trial for trial membership. 99 cents, and you get access to all our members-only content, including our detailed legal analysis of the Rittenhouse case, the McCloskey case, all of that.
What does a membership cost?
The normal price is about 33 cents a day, so less than $10 a month.
Okay, very cool. And with that, you get content that you're writing and producing that's just private for your followers.
Right. So just about every day we do a video, a podcast, a blog post that's some kind of plain English legal explanation or legal analysis of a case in the news. Obviously, right now we're focused mostly on the Rittenhouse case, but of course we covered the George Floyd case, the Ahmaud Arbery case, the McCloskey case, and we explain what's actually happening in these use of force cases from a legal perspective in plain English. So that's really the value we add to all this, is we translate all the legalese into plain English so people can understand what's going on. And then we also kind of pulled the curtain aside so people can understand how these decisions are made, what might be politically driving a prosecutor. For example, in this Rittenhouse case, most of the charges against Rittenhouse are not based on an intentional use of force. They're based on recklessness. Well, the reason the prosecutor's doing that is because the legal threshold the prosecutor has to meet to convict on recklessness is a lot lower than they need to convict for an intentional use of force. Now, when I look at the evidence, I don't see any evidence here that Rittenhouse did anything reckless. Every use of force appears to me to be purely intentional. But proving intent is much harder for a prosecutor than proving recklessness, so they decided to charge him.
How's that defined by law?
Basically, it's creating a circumstance of inherent risk, a dangerous circumstance, a circumstance that's a danger of serious bodily harm to someone, and then disregarding that risk. The classic example would be someone who drives drunk. Now, the difference between that and intent is that there's no intent to cause harm to a particular person. So the typical drunk driver is not looking to run anybody over, right? They had too much to drink. They're driving home. They're just trying to get home without getting arrested for DWI for the most part. So there's no intent to murder anyone. There's no intent to harm anybody. But what they're doing by driving drunk is creating an inherently dangerous circumstance and then disregarding that danger. So that's what makes it reckless. And that's what makes it different than intent. Now, that's different than if someone gets behind the wheel of a car and just decides to run over a bunch of pedestrians as an act of terrorism, right? That would be intentionally running people over. That would be a crime of intent. The drunk driver who runs somebody over, they never intended to hurt that person, but it's a criminally reckless act because of the danger they created. Now, if Kyle, for example, had just decided to do a mag dump in the middle of the street, spraying the gun everywhere, spraying gunfire everywhere, well, arguably that would have been reckless conduct. And I could see that as a basis for a charge based on criminal recklessness. But that's not what happened here. Near as I can tell, every shot he fired was directed at somebody who was attacking him. That's an intentional use of force in self-defense. That's not reckless. That's not creating a dangerous circumstance for no good reason and then disregarding that danger.
Correct me if I'm wrong, though. The jury could look at that and say the fact that you were armed on the street was reckless in itself. You were bringing a gun around all these people, creating a situation where violence already was happening, trying to seduce and elicit a response from people.
You know, the recklessness has to be really proximate to the harm caused. So you couldn't say, for example, that someone who went to a bar and had a beer, well, you know, that was the first step in becoming a drunk driver and therefore acting recklessly. Just having a beer in a bar is not reckless, criminally reckless conduct.
I see.
You have to progress all the way to becoming intoxicated, then getting behind the wheel of the car for the dangerous circumstance to be created.
So if I was in the bar saying, I'm going to drink 8 of these and go get in my car and see if I can race home, that's different than me just having.
Even then, that would be a reach until you've actually done that, engaged in that conduct, drank the beer. So Kyle going to Kenosha with the rifle for lawful purpose, which is, as far as we know, what was his intention, that's not reckless endangerment in and of itself. Now, if he did that and then he was a provoker or an aggressor, was challenging people to fight, well, that would be different. Then that conduct leads directly to the confrontation in which he has to use force. But there's no evidence that he was an aggressor or provoker in any of these confrontations. In fact, all the evidence is that he was in flight and he was being pursued. In fact, even if he had been the initial aggressor under Wisconsin law, under the law of every state, even if he had been the aggressor, when he started withdrawing from the fight, fleeing from the fight, well, that ended whatever the act of aggression was. That first fight's over. And now it's the people who are pursuing him that are the aggressors in a new fight, a second fight. Now, there's no evidence that Kyle was ever the aggressor in a confrontation, but even if he had been, by fleeing from that fight, it would have ended it, and a second fight would have occurred in which the other people pursuing him were now the aggressors in that second fight.
Good spot to add for all the do-gooders out there, and this gets people jammed up often. They become executioner or punisher, self-defense scenarios, somebody's being robbed or hurt, and now they give chase to the person that was the aggressor.
Right. So it works both ways, right? So if someone is chasing you, even if you were the aggressor initially, they become the aggressor if they're pursuing you. But the same is true of you. If someone else was the aggressor towards you and then flees and you pursue them, now arguably, even though you were innocent in the first confrontation, by pursuing them, you've now become the aggressor in a second confrontation. So definitely it works both ways.
Get back here. And then people get caught up emotionally in it. I only mention that just people listening, they understand how that can be applied to themselves.
Yeah, not fighting. If you cannot fight consistent with safety, that's a great way for normal people to win a fight. If you cannot fight consistent with safety, you've won that fight for our purposes, right? Our mission is not to be purveyors of justice or fairness out in public. Our mission is to get home alive, right? Survive any possible confrontation. And if we can do that by not having the fight in the first place, and I don't mean just, submit to criminal predators. I mean, consistent with safety. So you cannot fight and still get home safe. Other people you have a duty to protect, get home safe. You've won that fight for all practical purposes.
What's your biggest challenge? What's the biggest challenges you guys are facing right now, you, business-wise, et cetera?
It's a good question. I mean, I guess really our fundamental challenge is always just trying to grow our community, make more people aware of what we're doing. We have a very loyal following. I'm just a small town lawyer. For a small town lawyer, we do okay. I pay my bills. We're not looking to make $1 million here, so business is good enough for our purposes. But what I always find frustrating is when I see people who get jammed up, otherwise law-abiding people, never been in trouble with the law a day in their lives, and they end up getting convicted of a felony, usually because they deserved it. They earned it. They earned that felony conviction. And if you talk to them, they'll tell you they can't believe they got convicted for self-defense, because in their minds, they have a genuine good faith belief that what they did was lawful self-defense. But unfortunately, their belief is based on ignorance. And I don't mean that in a derogatory sense. I mean that in a technical sense. They're literally ignorant of where the legal boundaries are. They thought they knew where they were, but they stepped over the actual legal boundaries without even knowing they were doing it. And the law doesn't really care what you thought the law was. The law cares what the law actually is. And if you step over that legal boundary, however good your intention, you've broken the law. And if you break the law by threatening or using deadly force against people, and for a lot of these cases, these are people who got a concealed carry permit, they got a gun on their hip. So that's what they ended up going to when something scared them, or they felt an imperative to intervene in some kind of confrontation. They pull their gun out. Well, they've just threatened somebody with a deadly weapon now. And if they get charged and convicted on that offense, they're going to jail for 5, 10, 15, 20 years. And they're shocked. I'm not shocked, because I know where the legal boundaries are, and I understand why they stepped over that. And if they had known that, they also would not be convicted.
Yeah.
But unfortunately, they relied on the bad information that's so common out there, and they never got a good law-based, actual law, statutes, jury instructions, court decisions, education, and where those legal boundaries were. And their ignorance ended up putting them in prison for a good chunk of the rest of their lives. And that just did not have to happen. And I wish we could reach more of those people.
Especially now. So buy your book. So much of this information is free and available. It's not 1830 or something where you live out in the Old West and there's no internet and
we literally give thousands and thousands of copies of our book away for free every year. And that'll teach people 90% of what they know, what they need to know to avoid ignorantly stepping over those legal boundaries. And the book's written in plain English. The biggest compliment we get on the book is that it's easy to read, that it's not just legalese, that it's easy for people to understand. Most people I talk to read it in an afternoon, 3-4 hours. They've read the book cover to cover. And we always encourage people to, keep the book somewhere convenient, refresh your recollection, flip through it a few pages at a time after you've read it cover to cover, to keep the information fresh and actionable in your mind. But it's just not that hard to learn what you need to know to enormously reduce your risk of these kinds of, for all practical purposes, life-ending legal complications. And if I could give away 100,000 copies of the book a year, that's what I would do.
So go to lawofselfdefense.com for your free 100,000 copies.
Yeah, well, we'll give you one.
Parting words. I usually ask people if the folks listening or viewing never cross paths with you, if they never see you on this earth, what would you leave them with?
Well, we always try to leave people with this. If you carry a gun so that you're hard to kill, and that's why I carry a gun. I should mention that, I guess. I've carried a gun my entire adult life, had a concealed carry permit my entire adult life, including the 25 years I lived in Massachusetts, believe it or not. Always had a concealed carry permit there. And the reason I carry a gun is not to be a vigilante or impose my sense of justice on other people. It's so that I am hard to kill. It's so my family is hard to kill. That's why I carry a gun, not to protect my property, not necessarily to defend other people. That's really up to them, but to help ensure that me and my family are hard to kill by criminal predators. Well, if you carry a gun so that you're hard to kill, you also owe it to yourself and you owe it to your family to make sure that you know the law so that you're also hard to convict. not by learning legal tricks. We don't teach legal tricks, but by learning where the legal boundaries actually are, so that when you're defending yourself, you're staying well within those legal boundaries and not making yourself vulnerable to criminal prosecution and conviction and a long prison sentence.
I like that. I think that one thing I would add to that thought, not that you need me to add to it, but people listening, you made the point of legal tricks. Too often, I think the guiding principle that people have is it's lacking just compassion and empathy for other people. They're more concerned about, and I'm just making a broad generalization, but there's too many folks that are more concerned about exactly what they want, what they need. And if people started to look at how these complex choices affected others, maybe you wouldn't get in the pissing match on the side of the road or the shoving match out in front of the bar or whatever the stupid thing is that often leads to needless violence where guys are jammed up that otherwise were good people.
Yeah, it happens a lot. I mean, people get overly invested in what they think is right or righteous. It's not right that someone cuts in front of you in line at the movie theater. It's not right that someone takes a parking spot you've been patiently waiting for. It's not right that someone's using profanity at the restaurant table next to the table you're sitting at with your family and your kids. But is that any reason to engage in conduct that could lead to a physical confrontation? I would suggest not, because the stakes are too high. What you can lose if that escalates out of control is too high. And we just urge people to think through these scenarios ahead of time, keeping in mind what the bad outcome could be. The bad outcome could be a criminal felony charge and a conviction and a long prison sentence, or actually losing the physical fight, getting killed or maimed in the physical confrontation. What is worth those risks? Now, there are some things that are worth those risks, right? I'd rather be convicted of a felony in prison than dead. I'd rather be convicted of a felony in prison, have my wife dead or my kids dead. I'd rather be dead than have my wife dead or my kids dead. But once you get past that, the list of things that are worth possibly dying in a fight or going to prison for a long time, it's a pretty short list, right? It's hard for me to think of additional things that would be worth those kinds of risks.
Right. I love my truck so much that I'm willing to go to prison for it.
Right. Better be a heck of a truck.
Yeah, exactly. Or this is an interesting concept, especially nowadays. I'll have this conversation with people, maybe about some of the going-ons in America, and they'll say, but when's enough enough? I get it, man. So you want to stand up and hold this righteous moral line, but at what cost to you and your family? And I think it's easy to make the correlation. Well, isn't that what the founders did? Isn't that what the patriots of old did? In some senses, yes, but
they did it knowing they were risking their lives. They did it knowing that if they lost, they would be hung as traitors, right? Mm-hmm. So they made an informed decision. I'm not telling people not to make that call. If they want to counter-protest or whatever it is they want to do within the boundaries of the law, if that's what you feel compelled to do, go ahead and do that. I just urge people to make it an informed decision. Be aware of the risks you're incurring. If you're aware of the risks, you're making an informed decision. You're an adult. You're a free American. Do what you think you need to do. Just don't do it out of ignorance.
I like it. You folks that have watched, listened, if you dug this podcast, share it with your friends. If you've got a group of guys or gals that you hang out with and this topic has come up, share it with them. Too many people carry a gun and don't have a basic understanding of some of the legal concepts that we chatted with today. It's too simple, as Andrew pointed out, to invest some time, purchase his book, Law of Self-Defense, at thelawofselfdefense.com. Probably get that on Amazon and all those kind of places too.
Yeah, it's everywhere.
Okay, I thought so. I think that's where I've got my copy.
But I think if they go to our website, we usually have offers that are better than what Amazon has. I think on Amazon the book's $25, and I think that's the highest price we charge for the book. So it's not the first place I would go. One advantageous part of Amazon is there's hundreds of reviews. I mean, we have a solid 5-star rating on Amazon. So if anyone's uncertain about whether the book's as good as I say it is, well, there's hundreds of people on Amazon who will attest to what they perceive as the quality of the book. But generally at our website, we have better offers for the book than you find at Amazon. Unless, I guess if you're an Amazon Prime member, you'll save on the shipping. So people can find it both places.
If you guys dug this and you listen on iTunes or Google Play, leave a review, just like Andrew was just talking about. Check him out. Be well, be kind, don't be dickheads, and tell somebody that you love them. That's right.
Visit our website, carrytrainer.com, for information about classes held throughout the U.S., Carry Trainer apparel, and upcoming projects. You can also email us at training@carrytrainer.com for information about setting up your own private course or speaking engagement. Training@carrytrainer.com or carrytrainer.com.